Good morning, all of you. So, today it is the fourth talk in this series on Maoism. In the first talk, we focused on the overall Maoist movement, how it started in India, and how its journey was. In the second lecture, we focused on urban perspective, the strategy document of Maoist, what exactly they plan to achieve through that, and how it actually happens on ground, and few examples we saw in that series, in that lecture, in that session. The third session was about Koregaon Bhima riot, facts and fiction. So we tried to present facts which were not covered in mainstream media. Today, we are going to focus on the legal aspects of this Elgar Parishad case. Now, before we go ahead, I would like to uh, give a disclaimer here that I'm not a legal expert. So, if I happen to mispronounce certain legal jargons, please pardon me. Secondly, we are not going to get into all the details of this legal uh, case. I mean, there are so many nitty gritties. So we are just going to focus on the important aspects. So what we are going to cover today, first is uh, the scope of Elgar Parishad case. Second is sequence of events before the petition for SIT was filed. Then, who all is involved in this investigation and inquiry? The petition for SIT, which actually made national news, and it kind of grabbed attention because of this petition. This particular case grabbed attention of the nation. So, what happened in that uh, petition? How it went in court? Next is the charge sheets. So as of now, there are three charge sheets filed in this. So one is the first charge sheet was the main charge sheet, and the other two were supplementary ones. So we are just going to look into the important aspects of these charge sheets. And last one is bail pleas. Now, if we consider accused, like there are 14 as of now, so there are so many bail pleas. So we are not going to get into details of each one of them. We are just going to get into like few of them just to get an idea that what kind of things are going on. So let us start. Firstly, what is the scope of this Elgar Parishad investigation? When riot took place on 1st of January 2018, and later on there were cases filed, we covered those details in the previous session. In media, it was repeatedly mentioned that what these intellectuals or academicians has to do with the Koregaon Bhima riot, they were not even there. It is important for us to understand what is the actual scope of this Elgar Parishad case or Elgar Parishad investigation. So, firstly, the scope of this investigation is not restricted to finding out the object and effect of the program of Elgar Parishad, which was organized on December 31st, 2017. It is neither to carry out the investigation into the violence that followed the Koregaon Bhima. It is not just limited to that. I don't mean that it is not linked. Of course, it is linked, but it is not limited to that. But the investigation was expanded to unearth a much larger conspiracy of seizing political power through armed revolution by mobilizing masses by CPI Maoist, a proscribed terrorist organization. Now, who says this? So, this was mentioned in the affidavit which was filed by the investigating agency, that is the Pune police that time. So, when we talk about Elgar Parishad case, it is not just about that event of Elgar Parishad. It is not just about that riot which took place on 1st of January. Though the investigation started from that point, but later on it was expanded. Now, why it was expanded? Because during that process of investigation, the investigating agencies, they came across certain evidence which kind of unfolded different dimension altogether about this case, And it had a dimension in which a proscribed terrorist organization, CPI Maoist, was involved according to investigating agencies. And that's why the scope of this case is now much beyond Koregaon Bhima riot and Elgar Parishad. It is more about the functioning of CPI Maoist and the conspiracies by CPI Maoist, which is a proscribed terrorist organization. So, which all agencies are involved in this? We need to understand that when we say Elgar Parishad, so the case starts from the 8th of January, that FIR was filed on 8th of January 2018. Secondly, Maharashtra government that time, they convened uh, one inquiry commission, Koregaon Bhima Riot Inquiry Commission. Justice Patel, who is a former justice, he is the one who is heading this particular commission. So that commission is still going on. That work is still going on because of COVID. It was that work was somehow stalled. Now again, extension was given by Maharashtra government, and the commission has asked for a bigger place to conduct that inquiry, keeping in view the pandemic and the preventions to be followed. So that is where uh, the situation, that is where the commission work is currently. So commission work is still going on. Now, what the commission is trying to understand, or what they are going to, they are doing, people have submitted affidavits. Now, when we say people, that means whoever was there who felt like stating their observations, they submitted affidavits, and few affidavits were kind of we can say scrutinized, and some of them were cross-examined. The people who filed affidavits, so the cross-examination was done by this commission, and the work is not yet over. So that is where the work of the commission is. Now, when we talk about Elgar Parishad case, then there are three different uh, agencies involved. One is Pune City Police. So, 8th of January, the FIR was filed by Tushar Damgude. Later on, the investigation started by Pune City Police. Now, why it was started by Pune City Police? Because the place where that Elgar Parishad took place, that area, that location is Shaniwar Wada, which comes under Pune City Police, and that's how the investigation is with them. As far as Bide Ekbote case is concerned, then it is with Pune Rural Police, and that investigation is being taken care of by Maharashtra Police even today. In the month of January, this Elgar Parishad case was shifted or transferred to NIA. Why it was transferred to NIA? Because there are national and international connects involved. Keeping in view those dimensions, the case was transferred to NIA. Here we need to understand that whenever we talk about Koregaon Bhima riot, always there is a point of this Bide Ekbote case which is raised. So that Bide Ekbote case is still with Maharashtra government, it is still with Pune Rural Police. And only the Elgar Parishad case has been transferred to NIA. Now let us see what was the sequence of events before the petition for SIT was filed. January 8, 2018, as I said, FIR was filed by Tushar Damgude. Now this FIR was against 6 people. Out of those 6, as of now, Sudhir Dhawale is arrested, Ramesh Gaitsor is arrested, Sagar Gorkhe is arrested, and Jyoti Jagtap is arrested. Then, April 17, 2018, raids were conducted by Pune City Police. They found certain material in those raids. Those documents, whatever electronic material they found, it was sent to Forensic Science Lab. and the police received clone copies. Later on, the investigation process was followed. That electronic evidence which was received by the police, so the investigation progressed with that evidence. Keeping in view the content of the evidence, on May 17, 2018, UAPA sections were applied. So UAPA sections were not there in the beginning. The sections were added later on because the evidence was such that police felt the need that UAPA sections were added. June 6, 2018, raids happened and few arrests also took place. And on August 28, 2018, the second, what do you say, like in the first arrest, June 6th, there were 5 people who were arrested. On August 28th, 5 more were arrested. Now, this is the sequence of event till that petition for SIT was filed by Romila Thapar and team. Now, let us see what happened in that petition and what that petition was for. Romila Thapar and 4 more eminent personalities, they filed that petition. What were their demands? They said that the court should issue an appropriate writ order or direction directing an independent and comprehensive inquiry into arrest of these human rights activists. So one demand was that independent and comprehensive inquiry should be ordered. Second was that call for an explanation from the state of Maharashtra for this sweeping round of arrest. Third thing, immediate release from custody of all these activists. So this is what the main prayers were. Now, when this particular petition was filed, simultaneously, the accused who were arrested on 28th of August, they also uh, submitted affidavits, and similar prayers were made by those accused also. Now, let us see what happened after that. Now, we saw that what the petitioners wanted. An affidavit was filed by Government of Maharashtra. What that affidavit says, the important aspect is that affidavit mentioned that he has stated that the entire writ petition is based upon individual perception of the writ petitioners, that the arrested persons are all outstanding, well-known and well-respected human rights activists. So basically, according to the affidavit which was filed by Government of Maharashtra, the petitioners, they were making these prayers because according to them all these people were outstanding, well known and well respected human rights activists, and that was the perception, and that is how that petitioner that those prayers were made, and therefore their arrest requires to be inquired into and they should be released on bail. Now this is what the petitioners say. Having said that, he has asserted that in the instant case, the 5 named persons have been arrested not because they expressed dissenting views or difference in their political or other ideologies, but the investigation done so far has unraveled their involvement in a serious offense, including of being active members of CPI Maoist, which has been banned as a terrorist organization since 2009. Now, let us understand here that from day one, August 28th, 2018, when the arrest took place on 29th, immediately the petition was filed. Since day one, the Pune City Police or the Maharashtra government has been saying that this arrest is not about some different political views or different political ideologies. It is about the connect of these people with a proscribed terrorist organization, CPI Maoist. And it has been mentioned in that affidavit also, so it is on record. Secondly, The affidavit filed by Maharashtra government also mentions that what procedure was followed, because repeatedly it was mentioned that Pune police did not follow the proper procedure. That is what the allegation was. Keeping in view those allegations, the reply or the affidavit which was filed by Maharashtra government, it mentioned that the entire search procedure was videographed right from the time the investigating agency knocked at the doors of the respective individuals till the material recovered were seized, sealed, and panchanamas were drawn in the presence of independent panchas. During the said search, documents were recovered from their respective computers, laptops, pen drives, memory cards. Different documents were found to have been copied on different dates. The seized items were immediately sent for investigation to Forensic Science Laboratory, which in turn gave clone copies or mirror images to the investigating agency so as to ensure that pendency of FSL, that is Forensic Science Lab, report does not hamper the investigation. It is then stated that documents recovered from the seized items unraveled the information implicating the accused not only as active members of CPI Maoists but being involved in an ongoing sinister design of having committed and in the process of committing criminal offences, having the potential of destabilizing the society. The documents clearly reflect the preparation, planning, and coordination not only amongst the stated accused persons but with others subsequently arrested to carry out violence, including planned ambush, rebellion against the enemy, which is our country and security forces. So the crux is the procedure was followed. It was videographed since they knocked on the door. Since that moment, it was videographed, and then the whatever data was uh, collected, it whatever electronic evidence was collected was sent to FSL immediately, and the clone copies were received by police. So this states that the procedures were followed properly. Next is, it also says that the perusal of the evidence would reveal that the accused persons are not merely political dissenters but involved in sinister design, planning, preparation, and commission of criminal offences to destabilize the society. We need to understand that these people were not arrested just for giving speeches or just for keeping some literature at their home. They were arrested because, according to police, there is evidence that these people were part of a conspiracy. They were part of a sinister design. So that is what the affidavit says. Now, what was the verdict? Now, this particular petition, the verdict was 2:1. The majority, the majority verdict was given by Justice Khanwilkar and that time Chief Justice Deepak Mishra. So they mention here that we are of the considered opinion that it is not a case of arrest because of mere dissenting views expressed or difference in the political ideology of the named accused, but concerning their links with the members of the band organization and its activities. Now, we need to understand that the verdict itself is saying that it is not a case of political dissent, it is about the connect with banned terrorist organization. Next, the verdict also says that this is not the stage where the efficacy of the material or sufficiency thereof can be evaluated, nor it is possible to inquire into whether the same is genuine or fabricated. We do not wish to dilate on this matter any further, lest it would cause prejudice to the named accused. So the point is, this particular case was just about whether the procedures were followed correctly, whether that particular case or these arrests are about political dissent or something more than that. So clearly, the verdict says that the case is about political, uh, connects with proscribed terrorist organization, and it is not just about political dissent. Now, in this verdict, it was repeatedly mentioned that Justice Chandrachud gave a dissenting verdict. Now let us understand what did Justice Chandrachud said. He mentioned that in approaching the present case, the court must be mindful of the need not to thwart a criminal investigation leading to the detection of unlawful acts. Equally, the court has to be vigilant in the exercise of its jurisdiction under Article 32 to ensure that liberty is not sacrificed at the altar of conjunctures. Individuals who assert causes which may be unpopular to the echelons of power are yet entitled to the freedoms which are guaranteed by the Constitution. Dissent is a symbol of vibrant democracy. Voices in opposition cannot be muzzled by persecuting those who take up unpopular causes. Where, however, the expression of dissent enters upon the prohibited field of an incitement to violence or subversion of a democratically elected government by recourse to unlawful means, the dissent ceases to be a mere expression of opinion. Everybody has been mentioning, especially on social media, that time I noticed, or even in mainstream media, everybody was saying that Justice Chandrachud went against that verdict. He was not, I mean, of course, he gave dissenting views, but he did not question the merit of the case. He just wanted that SIT to be formed so that the processes would be ensured. So that is what his view was. He did not mention that there is no merit in this case. Let us see what he says further. Unlawful activities which violate the law have to be dealt with in accordance with it. In the background, which has been adverted to earlier, it would be Blaze to accept the submission that the investigation by the police should be allowed to proceed without a safeguard. So basically, he was demanding that there should be a safeguard and the investigation should proceed with SIT. That is what his point was. He categorically mentioned it it absolutely clear that nothing in this order shall be construed as any observation on the merits of the investigation which is to take place. The purpose of the direction which I propose to give is to ensure that the basic entitlement of every citizen who is faced with allegations of criminal wrongdoing is that the investigative process should be fair. So his only objective was the investigative process should be fair, and he is not questioning the merit. Secondly, later on in the month of October 2018, so like on 29th of August, this particular petition was filed. In September 2018, the verdict was given 2:1. So the majority verdict said that there should not be, the SIT is not required. There is no basis for which SIT needs to be formed. So Pune police, whatever procedures they are following, so they are following it properly. That is what the majority verdict said. And that is how the SIT was not formed. Now, in the month of October, again a review petition was filed by Romila Thapar and team. In that case, that particular petition was dismissed, and it was dismissed by all three, saying that we have perused the review petition as well as the grounds in support thereof. In our opinion, no case for review of judgment dated 28 September is made out. The review petition is accordingly dismissed. So whenever people say that uh, this particular case itself is fabricated or itself is baseless, there is no evidence, that is not true. There is very substantial evidence, and it has been uh, repeatedly proven that there is substantial evidence. Prima facie, there is evidence, and that's the reason all courts, starting from session court till Supreme Court, at the time of bail, at the time of these writ petitions, at the time of review petitions, it was repeatedly mentioned that The case is not about political dissent, and the case is about links with a proscribed terrorist organization. It was also mentioned that prima facie there is evidence. Now, there are three charge sheets filed so far. Let us look at it one by one. So, the first charge sheet which was filed, it was on November 15, 2018. It was some 5,000 odd pages. The accused mentioned in that charge sheet were these five: Surendra Gadling, Mahesh Rao, Shoma Sen, Rona Wilson, Sudhir Dhawale. In addition to that, there were five more people: Deepak alias Milind Teltumde, who is real brother of Anand Teltumde and who is a, a wanted Maoist. Then Kishanda alias Prashant Bose, Prakash alias Rituparna Goswami, Deepu and Manglu. So total 10 people, the total 10 names were there in the first charge sheet. Let us look at what are the highlights of this first charge sheet. So this charge sheet says that Elgar Parishad was held as per decisions taken at Eastern Regional Bureau of CPI Maoist in 2015. CPI Maoist hatched a conspiracy to form anti-fascist force during these meetings. The band outfit guided its operatives about different tasks, including acts of terror, as well forming a united forum comprising Dalits, tribals, and minorities. Operatives of CPI Maoist organized Elgar Parishad under the banner of Koregaon Bhima Shaurya Din Prerana Abhiyan. So basically, this particular event was organized by Koregaon Bhima Shaurya Din Prerana Abhiyan Samiti, and they say that approximately, some people say 200 organizations were there, some people say 100 organizations were there. It is important to note that not all organizations are being called as Maoist front organizations. Neither people or the members of all organizations are accused of being Maoist, though they were linked with organization of this Elgar Parishad case, Elgar Parishad. Only people who are linked with two organizations, so their names came to the front prominently. One was Republican Panther and Kabir Kalamanj. Inciting speeches at Elgar aggravated the violence at Koregaon Bhima. That is what the charge sheet says. Dhawale, Rao, Sen, Gadling involved in channeling funds for Elgar Parishad. So that is what the crux of the first charge sheet. Of course, these are just few important points I am writing. I try to highlight here. 5,000 pages charge sheet must be having much more than that. Once the trial starts, we'll get to know more details about it. Then supplementary charge sheet was filed in February 2019. It is some 1875 odd pages. Names of the accused in that supplementary charge sheet: Sudha Bharadwaj, Varvara Rao, Arun Ferreira, Vernon Gonsalves, and Ganpati. So he was the general secretary of this, what do you say, the CPI Maoist that time. Now he's not. So what the second supplementary charge sheet says: Rao and Advocate Surendra Gadling shared crucial information about security forces with underground operatives of CPI Maoist. Based on that information, the operatives carried out violent attacks against the security forces. The evidence seized from Rao, that is Varvara Rao, indicates that he is a senior member of CPI Maoist. That's what the charge sheet says. Rao, while in contact with Ganpati, also actively took efforts to achieve the goals of band outfit. The charge sheet also says that it accuses Rao of being in touch with senior Maoist member in Nepal, Basanta, who helped the former in procurement of arms and ammunition. Ferreira, Gonsalves, Bharadwaj of carrying out recruitment. So it accuses them of carrying out recruitment of operatives for CPI Maoist, while Rao, known poet, was accused of raising and providing money for the organization. So that is about some highlights of the second charge sheet. Of course, there is much more than that, but just to kind of get an idea, that is the highlight. Supplementary charge sheet 2, which was filed recently, it is 10,000 pages charge sheet, which was filed by NIA Now let us look into these details. Now we need to understand first that this is supplementary charge sheet. Now why I am raising this point? Interestingly, on social media, I came across a post by a renowned journalist in Maharashtra. He mentioned that this particular supplementary charge sheet does not talk about assassination of PM Modi. So basically, he was trying to hint that it was just a rumor and all these charges are fabricated and there is no mention of assassination of PM in this supplementary charge sheet. So he was trying to drive a point that, see, this is how this fake case was kind of presented. It is important for us to understand here that assassination of PM, so that particular aspect, that particular point was already covered in the first charge sheet, which was filed in the month of November 2018. And these charge sheets are in addition. The word supplementary itself says that it is in addition to those charge sheets. So this charge sheet is very much valid, and these are just supplementary charge sheets. But interestingly, when media decides that they want to raise question and they want to attack the credibility of the case, then this is how the narrative is built. So let us see what is there in supplementary charge sheet 2. So these 8 accused persons are mentioned in that charge sheet. Some important aspects. The Pune police had earlier filed 2 charge sheets in this case on 15th of November and 21st of February. NIA took up the investigation of the case on 24th of January. Through meticulous scientific and detailed analysis of more than 10,000 pages of communication made by various accused, reliable oral documentary and material evidence was brought on record. NIA's investigation revealed that the tentacles of conspiracy were not only spread throughout the country but also extended beyond India. So, this is one more point, one important point about this case. Secondly, the incriminating documents recovered from the accused include their discreet communications with other Maoist cadres regarding conspiracy related to violent incidents of Koregaon Bhima as a part of their well chalked out strategy. It also included various documents regarding mobilization against the constitutionally established government by the Maoist cadre, information about movement of the security forces with an intention to cause heavy damage to the state. Discrete codes were used for secret communication amongst themselves to avoid detection by security forces regarding their conspiracy and planning. This particular point, that secret communication amongst themselves to avoid detection by security forces. There was one point raised, again in media only, that the Maoists do not write letters to each other like this, openly disclosing their plans. So these letters, which police is presenting as evidence, must be cooked up. That is what the allegation was. We need to understand here that the material which was recovered by the police, once they got those clone copies from the forensic science lab. So in one of the press conference, it was mentioned by police that some of the letters they could recover, not everything they could recover till that time when they uh, conducted that press conference. So they were saying that they were kind of decoding these letters. So this evidence was not there, readily readable. They had to take help of forensic experts to get those things done. So that's what it means, that it was not a communication which was readily available like the media was talking about, that how they can write like that to each other. So it was surely with some protection, and that is the reason the material was not recovered fully. And that time when that press conference happened, it was mentioned that the process of recovering that material was in progress that time. Another thing is, investigation also revealed a systematic network of Maoists operating for supply chain of arms and ammunition, having close nexus with other banned proscribed organizations within and outside India. So it is not just with organizations within India, but outside also. The strategy and tactics adopted by Maoists to carry out so-called urban revolution with their frontal outfits has also been revealed during investigation. Besides this, funding activities of Maoist cadres and their sympathizers to carry out Maoist work in rural as well as urban areas came to the fore. We have already seen the details of the urban strategy of Maoist. We studied it in depth in our previous session. So it was not just about their work in rural areas, but the chart sheet also talks about their work in rural and urban areas. Another point is the absconding accused Milind Teltumde also organized training camps for imparting weapon training to other accused persons. So if we go through the details of this chart sheet, it is pretty clear that this case is not just about literature or uh, not just about uh, spreading the ideology. It is much more than that. It is about conspiracy and actual involvement in the conspiracy and the implementation of it. About Anand Teltumde, it says that Anand Teltumde, who normally resides in Goa, was one of the conveners of Bhima Koregaon Shaurya Din Prerna Abhiyan and was present at Shaniwar Wada on 31st of December. That is where Elgar Parishad program was organized. He played an active role with other Maoist cadres and received funds from them for carrying out the activities. Incriminating documents revealing his deep involvement with CPI Maoist activities also came to the fore. Uh, we did one video on contribution of Anand Teltumde towards Maoist front organizations. So that video is available on my YouTube channel Standpoint. There we just presented certain evidence which is already there in public domain. So certain organizations which were already declared as Maoist front organizations. So Anand Teltumde happened to be on the platform of those organizations and he made certain statements there. So all those details are there in that video. If you're interested, you may like to take a look at that. Then he was part of some fact-finding committees and was assigned the task to recruit cadres for guerrilla activities of CPI Maoist. His links with inter-service intelligence also came to fore. This is about Gautam Navlakha. Hani Babu, an associate professor in Delhi University, was instrumental in organizing visits of foreign journalists to CPI Maoist areas and was assigned present and future task of RDF, Revolutionary Democratic Front. It is a banned organization in Andhra Pradesh and Telangana. He was in contact with banned terrorist organization KCP of Manipur and was instrumental in making efforts for release of convicted accused GN Sai Baba, who is in jail currently. Then it also talks about Stan Swamy, who was recently arrested. So Stan Swamy is CPI Maoist cadre according to this chart sheet and was actively involved in its activities. Stan Swamy was in communication with other CPI Maoist cadre. He propagated among cadres that the arrest of urban CPI Maoist cadres from different parts of country, particularly in Maharashtra, has caused a huge irrevocable damage to CPI Maoist. He received funds from other Maoist cadres for the furtherance of the activities of CPI Maoist. So the crux is this charge sheet also gives in detail the reasons why these people were arrested and what is the level of their involvement. Now let us quickly look at the bail pleas or the quashing, the plea, there were requests for quashing of FIR. Now let us take example of Anand Teltumde. So November 2018, Teltumde filed a petition for quashing FIR, which was filed against him. December 2018, Bombay High Court rejected that plea. Then again, January 2019, Supreme Court refused to quash FIR against Anand Teltumde. So it was like till Supreme Court, it was that there were the FIR, the plea was rejected. Now, what exactly the court said, we are going to see it in subsequent slides. February 2019, Pune court dismisses Anand Teltumde's plea for anticipatory bail. So first he tried to quash the FIR, then he went for anticipatory bail. It was rejected. Then again, he went to Bombay High Court. It was rejected there also. He went to Supreme Court. It was rejected there also. And it is important what the Supreme Court said. It was mentioned that, in my view, there is sufficient material collected by the investigating officer to show the involvement of the present accused in the alleged commission of the offense, the judge observed. We are also going to get into the details of observations by other courts. Then on March 16th, when Supreme Court denied pre-arrest bail to Gautam Navlakha and Anand Teltumde, and the court asked both of them to surrender within 3 weeks. So by 8th of April, they were supposed to surrender. They again went to the Supreme Court giving the reason of COVID, and they said that their surrender should be reconsidered and they should be granted some more time. Again, Supreme Court just granted them 1 more week to surrender, and that is how on 14th of April both of them surrendered and they were arrested. Now let us see what the court orders say. So in case of Anand Teltumde, it is mentioned that Mr. Desai invited our attention to the article. Okay, so this particular point is about when he went to Bombay High Court for quashing the FIR. So that time, his lawyer, he made a point, and I would like to highlight that point here, because the way this particular case or this whole riot was presented as a caste based riot. I mean, it was like they tried to provoke people by kind of influencing them through the caste related narratives. However, Anand Teltumde, in one of his articles, I think it was written for EPW, in that he mentions that this 1818 battle of Koregaon Bhima, it had nothing to do with caste. That is what Anand Teltumde himself says. And interestingly, his lawyer, of course, he tried to get those uh, get that fact on record in this order, and he said that Elgar Parishad people, the organizers, were mentioning that that particular battle was between Peshwas and Mahar, so it was kind of Brahman versus Mahar, so it has a caste dimension to it. However, Anand Teltumde was of the opinion that that particular battle had nothing to do with caste. It was just that both the sides fought for their employers. So for few people, Peshwas were the employers, and for few people, British were the employers. So that is what his point was. And actually, he said it in one of his articles. I don't remember whether it was for EPW or for Wire, but in one of his articles, he said that. So that particular point was taken on record. Now, why I'm mentioning this is because this is the reality that that 1818 battle was not about Brahman versus Mahar. We have already explained those, we have already seen those details in our previous session of Koregaon Bhima Facts versus Fiction. However, here I'm just mentioning it because Anand Teltumbde himself said it and it is on record in one of the court orders. So that is something we need to take cognizance of. Secondly, uh, in one of the verdict that was again the for quashing of FIR, the court said that considering the rival submissions and the material produced before us, we are of the opinion that this is not a case where there is no incriminating material against the petitioner. So the petitioner is basically Anand Teltumbde. It is also not possible to record a finding that implicating the petitioner as one of the accused is malified exercise of powers on the part of investigating agency. The offense is serious, the conspiracy is deep-rooted and has extremely serious repercussions. The investigating agency must be allowed to have sufficient opportunity to collect evidence. The investigation is in progress. So this is what the verdict said. It was when Anand Teltumbde approached, I think it was High Court, for quashing FIR. Now, when he was denied anticipatory bail, like Gautam Navlakha and Anand Teltumbde, both of them were denied anticipatory bail. So that time again, okay, so here also the court said that I am satisfied that prima facie there is material against the applicant to show his complicity in the crime. Thus, even on the test of prima facie material involving the applicant in the crime, no case is made out for entertaining the application. So basically, they asked for anticipatory bail. So even while refusing that particular bail, the court again said that there is prima facie evidence. Then they went to Supreme Court. Supreme Court also denied their anticipatory bail in that they said that we are of the opinion that it cannot be said that no prima facie case is made out. Matlab, prima facie case is made out. The petitioners cannot be said to be maintainable in view of the bar contained in blah blah. However, since the protection has been enjoyed by the petitioners approximately for 1.5 years, 3 weeks' time from today is granted to them to surrender. The petitioners shall surrender their passport forthwith with the investigation agency oblique officer. So again, here also Supreme Court is also saying that there is prima facie evidence that these people are involved. If you see all these bail pleas, like even in case of Sudha Bharadwaj, September, October 2019, the Pune Session Court and Bombay High Court rejected bail pleas stating prima facie evidence. May 29, again, like this is more recent, NI Court rejected interim bail plea of Sudha Bharadwaj. August 29, again, High Court rejected that bail plea on medical grounds. September 24th, SC refused to hear the interim bail plea on medical grounds. So repeatedly, if you get into the details of all the bail pleas of all these people, all the courts, like from session court to high court to Supreme Court, it is repeatedly mentioned that there is prima facie evidence about this case. Even in case of Rona Wilson, Shoma Sen, Surendra Gadling, Mahesh Raut, Barbara Rao, Sudhir Dhawale, all of them. So on November 6, Pune Session Court rejected their bail application, and it also mentioned that there is prima facie evidence that they have links with a proscribed terrorist organization. October 23rd, 2020, again, NIA court rejected Stan Swami's bail plea in Bhima Koregaon case, quoting prima facie evidence. Now, I'm not going into the details of each and every bail plea. I just wanted to highlight that each and every court has repeatedly mentioned that there is prima facie evidence that these people have links with the proscribed terrorist organization. Now, let us get into one interesting fact. You must have heard about the Caravan. So, the Caravan came up with an article few years back. So that particular article was, I think it was in 2019. So that article was about the Pune police, whether they tamper with evidence against Bhima Koregaon accused. So in that article, they basically highlighted 6 points and they tried to create an impression that the procedures were not followed by Pune police. That is what they tried to create, that narrative they tried to create. To this particular article, because it was shared a lot on social media. So a rebuttal was written to this article by one IPS officer, Sandeep Mittal, and his rebuttal is important because one is he himself is a cyber expert, and secondly, he himself is a police officer. So he understands the procedures which are followed while investigating any crime. Secondly, he understands the technicalities of the cyber related legal aspects also. So all those 6 points with very objective kind of counter, he uh, wrote that rebuttal. You must go through that. I'm not getting into the details of it in this presentation. However, because the narrative was such in this particular article, I thought that it is important that this particular article must be shared in this presentation.